Thank you, Dennis. Mr. Ajit Sharma, Advocate on Record, Supreme Court of India. Mr. Sanpreet Singh Ajmani, President of Youth Bar Association of India and Advocate at Supreme Court. Dr. Poonam Rawat, Advocate and Principal of Law College Dehradun, and also Chairperson of Moot Court Society of the college. All the office bearers of Moot Court Society, President Ms. Anna Nupriya, Vice President Mr. Dennis, Convener Mr. Rahul Kumar Sharma, Gauri Agrawal, and all the office bearers. Dear participants from different universities and colleges, this is my proud privilege to welcome you all on the behalf of Law College Dehradun, faculty of Uttaranchal University, and of course on the behalf of Moot Court Society. You all are welcome in this online lecture series organized by Moot Court Society. Ladies and gentlemen, I believe that irrespective of the fact that all the efforts have been made by Bar Council of India as well as universities and colleges to frame the syllabi for the law graduate. But law being a dynamic subject, it is not feasible to accommodate each and everything in that. So what happened? Sometimes when we take classes in routine manner, there are few things, either they are not touched at all, or if touched, just to touch academically. And we feel that our students, when they go in actual practice, they surprise and find that there is a lot of difference between theory and practice. So keeping this into view, we have started this series of lectures from the experts, particularly those who are in practice, those who are in real practice in different courses, so that the student can have direct interaction with them. And this is why this online lecture series is started. And I am of the opinion that no doubt since last 2 months, we have been facing lot of difficulty because of COVID-19. But one more facet of this is that our lifestyle is completely changed. We have learned something by default which we were not doing earlier. And one thing is, now all the classes are going on online. And in some of the time, I feel that it is better than the real class. I find the attendance sometimes more than the real classes in the online classes also. We are taking an assignment, the students are writing, we are evaluating everything. So, at this point of time, the best part of it is, in our university, series of webinars are going on. Just now, I was attending another webinar on artificial intelligence with Taylor University of Malaysia and our university. So I found there was a topic about how the artificial intelligence can be useful for the lawyers and to read the mind of the judges. So like that, I feel that this is the time when the advocates, those who want to do something pro bono also, and like Mr. Sharma and Ajmani sitting before me, we can use and we can make use of their caliber, wisdom and practical experience. and this is what we have started this. And at this time, I will definitely mention that Youth Bar Association of India. Every time they have been very helpful. They have given us some technical support also, and for which I am not going to thank. That is the right. We can take it. So, as we are always together for so many events, so for that, except thanking to Ajmani, I will say my all the blessings are with you.
Thank you so much, sir.
Much of the time, Mr. Sharma, you are going to speak on the RIT, and this is one of the topic which is although we are teaching in the academic, you have been a student of Nalsar University, but everything cannot be covered up here. And now the time has come. I hope that with your experience in India and abroad, my student and also the student of different university of the country who are joined today also and last day also, they will be benefited. So once again, I welcome you, Mr. Sharma, on the behalf of my entire family, Law College Dehradun family. Thank you. Thank you so much.
Thank you, sir.
Thank you, sir. Now, without any further delay, we connect you to our speaker for today, Mr. Ajit Sharma.
Good evening, friends. The topic for today's discussion is law of writs. I think law of writs is such a relevant topic that there is perhaps never a bad time to have a discussion on law of writs and to sort of revisit the law every now and then on what are the developments in the law of writs. Now, this is something, as probably a lot of us know, is heavily covered by law school academic curriculum. We are taught the types of writs. We are taught what are writs as part of our curriculum, as part of our constitutional law curriculum. Most law schools devote extensive amount of time and research on this issue. The idea today is to not just sort of revisit that as to what is the law of writs, what are the types of writs, when can they be invoked, but to give you a litigator's perspective, because I think that is where it really becomes very important. For those of us who are aspiring litigators amongst the audience here, please understand that in the High Court, a significant part of our practice in the High Court is on the original side, litigating writ petitions. Now, that's a significant part of our practice. And therefore, writ practice today is, for any litigator, an area where more than basic expertise is essential, is imperative. And therefore, one must know that when filing a writ petition before a High Court to seek substantive justice for your litigant, what kind of a writ, what kind of a prayer must be sought from the court, what is the process by which the court's writ jurisdiction can be invoked, whether a court can be approached or not, what are the prerequisites. So those are the kind of details also that we will touch upon. Now, just before much ado, some house rules. This is supposed to be an interactive session, so please feel free to not park your thoughts till the end. If there are any questions, you think there are important questions on something that I'm directly dealing with, please feel free to flag them off right away and discuss. And towards the end of the session, I note that we have about 10-15 minutes time devoted to a Q&A. So feel free to ask any sort of questions that you think I might be able to help you or assist you with. All right. Now, writs is essentially, it's a legal word now, but writs is essentially, as it literally means, is a command. It originated in medieval England, perhaps even before that, where the writ was a power that accrued to the crown. So this power was exercised by the crown through King's Bench, as we now have Queen's Bench in England, depending on who the crown in England, who wields the crown in England. But this power is exercised through the appropriate courts in England at the command of the crown. So the power vests with the crown and is exercised by the forum, which the crown has created, which is the King's Bench there or the Queen's Bench now. And then this particular bench would exercise this power of issuance of several types of writs, whether habeas corpus or certiorari or prohibition, or whatever different kinds of writs which we'll come to pass appropriate orders, whether it be to direct a lower court to do something, whether it be to direct a particular authority to do a particular action. So all of this power was exercised by the court in the name of the crown. And therefore, as the name suggests, the crown, through the forum concerned, the bench concerned, would issue a writ directing a particular governmental authority or a particular court to do or to not do certain acts. And therefore, the writ must be complied with. The command of the sovereign, the command of the crown must be complied with. That's the origin of the word writ. Now, writs, as they developed, however, developed into various types of writs. So, for instance, a certain kind of commands came to be issued quite often. For instance, habeas corpus to challenge illegal detention. Personal liberty has been absolutely critical since the times of Magna Carta in England. So, courts started issuing a particular kind of writ a lot more than the others. This writ was habeas corpus. It's something that's found that finds mention not only in our constitution but in the constitution of a lot of other countries. U.S. Constitution, for instance, also names habeas corpus specifically and protects the rights of its citizens to invoke the court's remedy and to approach the courts for issuance of a habeas corpus writ, essentially to prevent against wrongful detention. So these writs are prevalent across the Commonwealth. In India, however, the introduction of these writs in our constitution is not just colonial legacy. The Constituent Assembly did debate thoroughly about whether to introduce constitutional remedies by way of specific provisions, whether to specifically empower courts in India to issue writs, in what situations could the power be exercised, when can the power be not exercised, how broad and liberal would the exercise of this power be. So it was a very conscious and a deliberate effort to put certain provisions in the Constitution of India so as to permit the people of India, whosoever is in India, citizens, fundamental rights accrue to citizens, some fundamental rights accrue to non-citizens as well, and to enforce those fundamental rights before the superior courts, the High Court and the Supreme Court. There was a lot of discussion, and therefore, for us, is not just something that we have inherited from Britain, but it is something that we, as a conscious choice, as a matter of fact, decided to put in our constitution. Now, in fact, that also brings me to an often quoted quote by Dr. Ambedkar, who said that the Article 32, which is the constitution provision providing for the power of the Supreme Court to issue writs, is the heart and the soul of the constitution. Right? So straight away, now let's come to Article 32. Now, there are two articles in the Constitution which specifically name the word writ, and these two are Articles 32 and Articles 226. Now, Article 32 first finds place in Part 3 of the Constitution. Now, Part 3 of the Constitution, as we all know, comprises of Articles 12 to Articles 35, which deal with the chapter on fundamental rights. Now, US has a Bill of Rights. The idea perhaps came from there, but our Constituent Assembly also decided that we must have a specific chapter which specifically guarantees fundamental rights to Indian citizens. And those rights were enunciated up until Article 31. Then, for enforcement of all of these rights against state, a separate provision was incorporated in the Constitution, which provision also is a fundamental right. That is Article 32. The meaning of all these legalese is essentially this, that if suppose you are drafting the constitution tomorrow of a country and you want to give your citizens a whole bouquet of rights, then those rights are essentially meaningless if you don't specify the means by which the people of your country can approach the courts and demand those rights, demand enforcement of those rights against the state. So therefore, one must be able to approach the court and say that, Mr. Judge, this is what Article 32 says. This is what Article 19 guarantees me, freedom of movement, and I demand that you tell a particular state, or you tell a particular transport corporation, or you tell a particular metro corporation or another entity to permit me my right to freedom of movement, freedom of speech, and I demand this right, and I can enforce this right by virtue of Article 32. So therefore, the means to enforce each of these rights was provided for in Article 32. And Article 32 itself is also a fundamental right, which means that it can't be abrogated, which means that the limitation of Article 13 will apply. Article 13 says that state cannot make any law which violates or contradicts your fundamental rights, and any such law is void. So therefore, any law which seeks to limit judicial review, which seeks to say that Supreme Court, you cannot entertain a petition enforcing somebody's freedom of speech or freedom of movement, any such law which sort of ousts the jurisdiction of the court would itself be contrary to the fundamental right guaranteed by Article 32. Right, now let's look at Article 32 a little closely, because I think a lot of times what happens is we read a lot about what Articles 32, 226 say, but the details are essentially like always in the fine print. And perhaps every time you read these articles, which are so key to not just a litigator's practice, but even to understanding the concept and the key idea as to how liberties and freedoms are enforced in our country. Every time you read this, you will perhaps understand or learn something new. I do, even till date. And there is a fair amount of research and jurisprudence on these two articles as well. So it's always a pleasure to read up these articles and the jurisprudence on them. Article 32 comprises of 4 sub-articles. Now 32.1 says that the right to move the Supreme Court by appropriate proceedings for enforcement of rights conferred by this part is guaranteed. Those are the critical words here. Now Article 32.1 says that Article 32 forms part of Chapter 3. Chapter 3 is titled Fundamental Rights. Your right to approach the Supreme Court to seek enforcement of your fundamental rights is guaranteed. So therefore, no law by the Parliament tomorrow can say that an Indian resident cannot approach the Supreme Court to enforce his or her rights guaranteed under Part 3, to seek enforcement of his or her fundamental rights. Any such law would run not only counter to Article 13, but also run counter to Article 32.1. So 32.1 says that you can knock the doors of the Supreme Court as a matter of right. This is guaranteed by the Constitution. Nobody can take that away. The Supreme Court can't say that you cannot approach my forum at all for enforcement of your fundamental rights. Now, there are certain exceptions which are more like rules of convenience, which have been crafted by the judiciary to not refuse enforcement of this right, but to perhaps redirect a litigant to an appropriate forum to seek enforcement. But the right to move the Supreme Court is guaranteed, and the Constitution says so in so many words. It uses very simple English and uses so that there is no ambiguity in the language of 32.1. This guarantee is extremely important. The purpose of this guarantee is that everyone can approach the highest court of the land to bring to the court's notice that, see, Supreme Court, this is what the state of ABC or Union of India or a particular state or public authority is doing to me. And you can bring this directly to the notice of the Supreme Court, and your right to bring that to the notice of the Supreme Court is guaranteed by the Constitution. Now, 32.2, most importantly, vests certain powers with the Supreme Court. So it says that once under 32.1 some litigant approaches the Supreme Court for enforcement of their fundamental rights, then under 32.2, Supreme Court has the power to issue a number of directions. So, for instance, the language of 32 is that Supreme Court shall have the power to issue directions or orders or writs, including in the nature of the 5 prerogative writs, for enforcement of fundamental rights. So, therefore, there are 3 components as to what Supreme Court can issue. It can not only issue any of these 5 prerogative writs which are prevalent from the time of King's Bench in England, but it can also issue any other writ. So tomorrow, for instance, there can be a 6th writ or a 7th writ that can be evolved if circumstances so permit. We are not necessarily restricting ourselves to only these 5 writs. The ingenuity of lawyers can perhaps permit evolution of a new kind of writ as well. There is no restriction. It can not only issue writs, but Supreme Court also has the power to issue any direction or any order. Now, this is as vague and as broad as it sounds. And it was intended to be so vague and broad. So if, for instance, you are a Supreme Court judge and somebody comes to you to say that my right to freedom of movement or my right to practice the occupation of my choice guaranteed by Part 3 cannot be practiced because the state has passed a law imposing so-and-so restrictions on my rights. Now, Supreme Court can not only issue one of these 5 writs, but if suppose the order that the court wants to pass is not covered by any of these 5 writs, then it can also pass any order or any other direction to ensure that you, the citizen of India or the resident of India, is actually able to exercise your right. And the fact that there are only 5 writs will not restrict the ability of the court to pass any such order it wants in the interest of justice, to ensure that you have the complete and absolute freedom to exercise your rights in terms of how it's provided in the Constitution. No rights are absolute, of course, but the way it's provided in the Constitution. So therefore, 32(2) vests a power with the court. Now, here I want to sort of pick your brains on an interesting issue that I came across when I read 32(2) again, and which led me to reading some literature as well on the issue. See, 32(1) imposes gives a right to every citizen to approach the court, but there is no corresponding duty on the court to pass orders or to protect those rights. Now, that's how it seems that the language of 32(2) is couched, because 32(2) gives or vests a particular court with certain powers. So if you're the Supreme Court, you have the power to do ABCD things. You have the power to issue any directions, courts or writs or orders. You have that power. But are you bound to issue those writs or orders or directions when somebody approaches you and makes out a case for violation of fundamental rights? No, you're not bound to. It's your discretion as of now. So therefore, as a court, you don't have a corresponding duty to always issue a direction or an order or a writ to protect somebody's right. You can say that Mr. So-and-so or Miss So-and-so, while you make out a fair case that your rights are perhaps violated, fundamental rights, we are in exercise of our discretion directing you to go before the High Court or to go before an appropriate forum or to exercise a statutory remedy available. We will not entertain this particular petition, even though you make out a prima facie case of violation of rights. So therefore, that's where the dichotomy is. A lot of scholars say that this is not okay, that when somebody approaches the court and is approaching the court is guaranteed by 32(1), then therefore the guarantee must have a corresponding duty on part of the court. A litigant can't be left in the lurch to say that, see, 32(2) gives you the power to issue certain directions and writs, but there is no duty upon you to issue those powers. So that sort of, some scholars like Professor Upendra Bakshi in one of his articles has argued that this in fact amounts to a refusal by Supreme Court to entertain a refusal to entertain a petition under Article 32, even though a litigant makes out a prima facie case of violation of his fundamental rights, effectively amounts to amending Article 32, which judiciary cannot do. Because judiciary, in his view, the Supreme Court in his view must always respond to a litigant who says my fundamental rights are violated. The Supreme Court has a corresponding duty to such a litigant. Right, so read up on this issue as well. Perhaps you can flag this and let me know what your thoughts are on this issue. But it's an interesting issue, so I thought I'll share with you. But at this point in time, as we speak, there is no corresponding duty on the Supreme Court, and it's a discretionary exercise of the power by the Supreme Court. So in its discretion, in its wisdom, in its as a matter of choice, even in the right facts, the Supreme Court can refuse and dismiss a petition under Article 32. Now, from a litigator's perspective, I can tell you that Article 32 petitions in Supreme Court are far and few. They're not rare. There are a significant number of Article 32 petitions filed in the court every year, but it's an exception to the norm. It's not the norm to approach the Supreme Court under Article 32 every time a litigant approaches an advocate and says that my rights are violated. You must look at other options. You must look at other remedies. You must look at statutory remedies. You must look at why you cannot approach your parent High Court where you're situated. And if, in spite of all of these factors, there are enough reasons for you to approach the Supreme Court in Delhi, then you approach the Supreme Court. So it's not the norm, it's an exception as to why you must approach the Supreme Court under Article 32. And in my experience, a lot of times, the Supreme Court tells you that, see, the violation of your fundamental rights, yes, you do sort of make out a case, there is some merit in what you're saying. But it appears that the violation is by a particular state entity. It is not by multiple states. Suppose you stay in Noida and you claim that your rights by state of UP are violated. Or you stay in Uttarakhand and you say that my rights by the state are violated because the state is imposing unnecessary restrictions on my freedom of movement. Now, you can't take this plea before the High Court of...
నేను ఇది నేను కరెక్ట్ చేసుకుంటున్నాను ఉన్నది.
Yeah, so you can take this plea before the concerned High Court as well. And the Supreme Court will say that, that particular High Court is perhaps a better forum to address your grievance. And you approach that High Court, and then you approach the Supreme Court, so that the Supreme Court also has the benefit of having an order from a High Court and to read that order. If you still have a grievance against that order, then you approach us. So that's how, as a practical perspective, the court sometimes relegates the litigants to the concerned high courts or forums. Now, the other interesting aspect about Article 32 is that Article 32 cannot be suspended except as provided for in the Constitution. So it's your fundamental right to approach the Supreme Court to seek enforcement of your fundamental rights. It is Supreme Court's discretion to allow or to disallow your petition. But your right to approach the Supreme Court cannot be suspended, except for obviously under 359 in an emergency, when Parliament may by law suspend the enforcement of fundamental rights. That too, 20 and 21, Article 20 and 21 cannot be suspended, but the others can be. So invocation of Article 32 can only be suspended for a limited period of time while the emergency is in force. It's only happened once, as we all know, so far. All right, so I believe we've touched upon Article 32 briefly now. That is an extremely important provision for at least those who aspire to practice in the Supreme Court. It is, as I said, something which is often resorted to by litigants in the Supreme Court coming from different parts of the country, and it is specially resorted to in areas which have impact on several states. So, for instance, if a particular law is passed by the Parliament, which would have ramifications across all over the country or over multiple states, then it is perhaps prudent to approach the Supreme Court directly rather than approach one High Court. Although there is no bar as such, but that would perhaps be one of the situations where one would approach the Supreme Court and say that because it has pan-India implications, therefore we are approaching the Supreme Court and not just the High Court. All right, the other provision in the Constitution now, which specifically mentions the word writs, is Article 226 of the Constitution. Now, like Article 32, which gives the power to the Supreme Court to issue certain writs, Article 226 confers similar powers on the High Court of every state to issue certain writs. Now, this Article 226, however, is couched in a very wide and much broader language than even Article 32. So, remember one thing, Article 32 is part of Chapter 3, is part of Part 3 of the Constitution, and is itself a fundamental right, which means your right to approach the Supreme Court cannot be taken away, but your right to approach the High Court is not a guaranteed right, like Article 32. So, High Court can tell you that I am sitting in pure exercise of discretionary jurisdiction. This is my extraordinary jurisdiction. You don't have a right to approach me under Article 226. So therefore, I'm refusing to exercise jurisdiction under Article 226 because I believe that you can approach another forum, or I refuse to entertain this petition. So therefore, there is no guarantee associated with Article 226. I can approach the Supreme Court and say that, sir, my filing of this writ petition and your hearing of this writ petition is something that is guaranteed to me by my Constitution. I can't say the same thing for the High Court under Article 226. Under Article 226, I'm almost entirely at the mercy of the High Court concerned, and my arguments in Article 226 are constructed in a way to convince the court to persuade the court to exercise its discretion, because there is no guarantee associated with approaching the court under 226, unlike in 32. So now, the reason why 226 is couched in a much wider language, I say, is because while Article 32 says that any person in India can approach the Supreme Court for enforcement of his or her fundamental rights, Article 226 goes beyond this to say that anyone can approach the High Court for enforcement of not only fundamental rights, but for any other purpose. Now, these three words and for any other purpose, these four words, and for any other purpose, basically are not just very vague and broad, but enlarge the scope of High Court's powers tremendously. Now, these four words, that anyone can approach the High Court for protection of fundamental rights and for any other purpose, have been interpreted by the Supreme Court in a number of judgments. And Supreme Court has always said that, see, these four words, that anyone can approach the High Court to get to protect their rights or for any other purpose, enlarge High Court's jurisdiction to touch upon virtually every aspect of a person's interaction with a state entity. So High Court has no fetters or limits or restrictions on its jurisdiction under Article 226. Whether it should exercise its jurisdiction or not is a different matter altogether. But one will find it very tough to say that High Court lacks jurisdiction completely to entertain a petition under Article 226. Now, there are two ramifications to this. One is that you can approach a High Court for enforcement of a right which is not a fundamental right. Right? You can approach the Supreme Court only for enforcement of fundamental rights guaranteed by Part 3 of the Constitution. You can approach the High Court for enforcement of rights in addition to fundamental rights as well, because this is covered under any other purpose under Article 226, the words under any other purpose. And as I said, Article 226 itself is not a right, so you don't have a right to approach the High Court. Okay. So this is essentially the critical difference between Article 226 and Article 32. Now, Article 226 is something that's more often resorted to. Any litigant who comes to a council to say that my rights have been violated is more likely to approach the High Court, because it is not only a convenient forum, it's not only a forum which is closer to the litigant, but it is also a forum which has a wider and a more broader jurisdiction than the Supreme Court. So therefore, there is a hierarchy which is enforced implicitly by the way these two provisions are worded, and both these provisions are meant to confer upon the respective court's original jurisdiction. Right. So as I said, that under Article 32, it is your right to approach the court. Under Article 226, you can approach the High Court and request the High Court to exercise its discretion. Both of these are original jurisdictions of the Supreme Court and the High Court, meaning thereby that as opposed to appellate jurisdiction where you're coming and challenging orders of lower forums, you are directly approaching the High Court, you're directly approaching the Supreme Court to seek redressal of your grievance. Right? So you're bypassing all the forums perhaps which may exist, which may not be in existence, that's another thing. But even if there are forums which may exist, you can bypass all these forums and approach these two courts directly under the respective articles in exercise of their original jurisdiction. So these are original courts in that sense of the term. Now, actually, while we are on that, just for a moment, just imagine if, for instance, there were no writ provisions in the Indian Constitution. Now, how would one seek enforcement of your rights? Now, if there is no Article 32, there is no Article 226, what would a citizen do? In that case, you would have to file a civil suit where evidence is led, pleadings are led. It's a long drawn process. Strict rules of evidence procedure will apply. And then perhaps you can get a declaration from a court, a decree from a court that, yes, Mr. State, you've done something wrong. Please restore her, the litigant, her rights. All of this process, this tedious process is bypassed. And that's what Dr. Ambedkar said in the Constituent Assembly as well, that we need original jurisdiction to be conferred upon the superior courts in India, the High Court and the Supreme Court, so that these delayed, elongated, long-drawn procedures can be bypassed. And these two superior courts can straight away look at the bird's eye picture and say that, yes, something patently wrong is happening here in respect of this litigant, and we need to protect his or her fundamental rights. Now, also remember that, as I said, petitions under Article 226, Article 32 are an exception to the norm. So cases which are heavily fact-centric, which involve heavy interpretation of facts, cases where two individuals are at loggerheads with each other, those cases are not resorted to or adjudicated in a writ by way of a writ remedy. A writ court is here to interfere only in those matters where a litigant is able to convince the court that, sir, dehorse the facts of the case, dehorse the facts that a tender was issued and tender terms are so complicated, or dehorse the fact that there is a dispute of land, my land is X acres, his land is Y acres, all of that, dehorse all those facts, which I don't want you to get into. Please note that a particular right which is guaranteed to me is sought to be taken away in this particular manner. So that's when the High Court will interfere, right? So just to give you an analogy, for instance, if suppose somebody takes away your land, the state acquires your land, and the state says that you will have no redressal against the acquisition. The acquisition by me, the state, of your land is full and final, no remedy at all. The compensation that I choose to give you is full and final, no remedy at all. Or the state says that, all right, you have one remedy, there is a one-man commission, he or she will not follow any rules of procedure, will decide your challenge to the acquisition. Now, in such a case, you can approach the High Court and the Supreme Court to say that, see, I understand that my land has been acquired by the state for a particular purpose. I'm not going into whether the purpose is genuine or not, whether there is genuine need by the state. But I'm coming to you, the writ court, the Supreme Court, because the remedy that I have, that one-man commission, is a nullity. That remedy is pointless. That one-man commission does not follow principles of natural justice. So therefore, I'm not going to get any justice from that commission, and therefore I'm coming to you. So in such an in this illustration, for instance, you're not harping on the facts of the case. You're harping on a larger aspect, that the acquisition, whether it is right or wrong, is a different matter of land. But the fact that the remedy provided by the Act, which permits acquisition and which permits you to challenge the acquisition, that remedy is insufficient. And therefore, the writ court must interfere to protect your rights, your right to property under Article 226. So, therefore, please remember that these are not remedies, these are extraordinary remedies which are not to be utilized for resolution of private disputes. These are public law remedies. A writ is a public law remedy, which means that a necessary party must be a public forum. As we say, one of the first principles is that in a writ petition, the primary respondent must be the state, or an entity which performs functions akin to that of a state. Because the idea is that the state is supposed to protect your fundamental rights. And if Mr. X, an individual, has, for instance, kidnapped me and put me in his or her wrongful custody, then it is for the state to ensure my release, and it is for the state to protect me, my right to liberty and life. And therefore, I will approach the court to say that, court, please direct the state to ensure that my fundamental rights are protected and exercised. And you may also make that individual as a party in that petition, but the primary respondent has to be the state. Primary respondent, primary prayer, the relief that you are seeking has to be against the state. So if two people are seeking to partition their land, then a writ petition is simply not admissible, because there is no purpose that a state will serve in such a dispute. If my land is situated in Dehradun and there are four brothers who are saying we need 1/4 of land each, but whether I need the north corner or the south corner or which part of it, state of Uttarakhand has no role in this litigation at all. Right? So therefore, such litigations cannot be redressed, because these are private remedies. These are not public law remedies. A public law remedy, by its very nature, involves a public forum, involves a public entity. And what is a public entity is a matter of different discussion. Now, there is Article 12, which very broadly defines what is state. Not only state governments, but any authority working under the state is also a state in terms of Article 12. So you must have, in every writ petition, the primary respondent, the primary party against which you are seeking a relief, should be state. Now, I just digress here for a moment because it's important, I think. From a litigator's perspective, often the way Article 12 jurisprudence has evolved, the way definition of state has broadened. Supreme Court, for instance, in Z Telefilms, which is a landmark judgment, interpreted Article 12. And before that, in Anadi Mukti also, it's a very important judgment. I'll send out a list of judgments that I think are relevant separately to Rahul, so you all can read in your free time. In these two judgments, Supreme Court said that a private entity also, which performs functions which are in the nature of functions performed by the state, a writ is maintainable against those entities as well. So So for instance, if I go to a particular hospital and the particular hospital does not refuses to treat me, for instance, says that no, I will not let you enter my hospital, even though you're about to you're suffering from an ailment, I will not let you enter. Now that hospital serves a public function. It ensures the presence of a hospital is part of state's endeavor to provide right to health, right to good health and dignified life to all its residents. And therefore, state has allotted lands at cheap rates to all these hospitals. Therefore, hospitals serve a very important public function. Schools, universities serve very important public function. And Supreme Court has held in a number of judgments that even though it's a private college or it's a private hospital, where these institutes or hospitals essentially utilize some kind of public funds, a writ petition can be filed even against such private entities, because these private entities essentially carry out public functions, which state does, right? So that's the second bit as to on maintainability of the writ. We've so far discussed two articles, 32 and 226. We've discussed once you approach the particular forum under these two articles, what are the things you must keep in mind? One is you must keep in mind that the state is a party. Second, you must keep in mind that it is not a private dispute that you are seeking to redress, it's a public dispute. And third, you must seek in mind that there are no effective alternate remedies available with you. So I'll explain this best with an illustration, for instance. Election petitions, let's say, for example. Now, if I'm contesting an election and I lose an election and somebody else wins the election, then I'm challenging that person's election on certain grounds. That person, for instance, did not comply with the election laws and procedures, did not comply with the model code of conduct, so on and so forth. Now, the Representation of People's Act gives me a remedy, a statutory remedy, that there is something called an election petition. If you want to challenge somebody's election, if you've lost an election, please file an election petition. This is the format, these are the grounds, this is how the election petition will be decided. Now, can I, in such a situation, say that I don't want to file an election petition, I want to approach the Supreme Court under Article 32 because my fundamental right has been violated, or I want to approach the High Court under 226 because my right to contest an election was violated, which is not a fundamental right, but a statutory right. The High Court in such situations is more likely to say that, sir, you please go back and approach the appropriate forum. There is a statute dealing with the exact grievance that you have. There is a forum created. That forum we find complies with the procedure of natural justice. There is nothing wrong with that forum. So why have you come to us? We, as a writ court, are exercising extraordinary jurisdiction, and where you have an alternate remedy, please exercise that. Right? So keep that in mind, the alternate remedy. But at the same time, there is a recent judgment, Justice Chandrachud's judgment, a 2019 judgment, where he says that the principle of alternate remedy is not a ground to completely oust the jurisdiction of High Court or Supreme Court under Article 226 or 32. You see, we read Articles 32 and we read Articles 226. Now, the articles themselves do not contain any restriction. Article 32 does not say that Supreme Court will not entertain a petition where the litigant has an alternate remedy available. Neither does Article 226 say this. So therefore, this limitation is a self-imposed rule that the courts have invented on their own. This rule is to be exercised. When is it to be exercised? When is it not to be exercised? Depends on a case-by-case basis. If the facts of your case are so shocking so as to warrant interference, even though an alternate remedy exists, the court will exercise its jurisdiction. It's not powerless. So it's not a rule cast in stone. It's not an absolute rule that just because there is an alternate tribunal available to hear the same grievance, I cannot ever approach the High Court under 226. You can. At worst, the High Court will relegate you back to the appropriate forum. That's the worst that will happen. Right? So please keep that in mind, that it's a rule of convenience, not a rule cast in stone. It's a rule which is meant to ensure order and hierarchy in judiciary. It's not a rule which is meant to dilute in any way the powers under Article 226 of the High Court or the Supreme Court. And there is a judgment which I'll send out again, where Supreme Court has laid down criteria as to where, even though an alternate remedy exists, if the remedy is not efficacious, if the remedy is not effective, the High Court will entertain the writ petition, even though there is an alternate remedy that exists. The last thing one must keep in mind before approaching a writ court is the clean hands doctrine. Now, all said and done, you cannot very selectively disclose certain facts to the court and hide or omit to disclose the other facts. When you approach a writ court, you must tell the writ court the entire set of facts. We say that all material facts and all relevant facts must be disclosed. So you must say that I've written to a particular authority, give me all of these rights. These are my rights. The authority has written back saying that no, we will not enforce you these rights. The entire correspondence must be disclosed. It shouldn't be that you've omitted certain correspondences with the state government, and ultimately the High Court finds out that state government had actually permitted you exercise of your fundamental rights, which you concealed from the High Court. In such cases, the courts will come down heavily. They may even impose costs and dismiss your writ petitions. So therefore, please ensure that there is full disclosure, that the writ is not used to settle personal disputes, that there are no alternate remedies that you may have exhausted before approaching the writ court. These are the, by and large, three general principles before we approach the writ court under Article 226 or 32. Now, there are 5 types of writs. I don't want to spend much time on this because I assume that you've all dealt with these 5 writs as part of your curriculum, but I'll just touch upon these writs very briefly. Perhaps 2 of these which I find most interesting are, there are 5 prerogative writs, as we call it. These 5 writs are mentioned by name in the Constitution in both Articles 32 and 226. These are writs of habeas corpus, certiorari, quo warranto, prohibition, and mandamus. Now, habeas corpus perhaps is very significant here. Habeas corpus writ was very common at one point in time because it is filed by somebody who feels that he or she has been illegally detained by the state. So police has the power to arrest. The most general example, for instance, if the police comes and arrests you illegally, then you can approach the High Court or you can approach the Supreme Court and seek a prayer in your prayer that a writ of habeas against the police, the state government, and so that I be released, the person be released. Right? So habeas corpus literally means that you produce the person from the custody before the court so that the court can see that the person is fine, is alive, and then adjudicate whether the custody of that person is right or wrong. On habeas corpus, there is a whole huge body of law on habeas corpus as well. But perhaps a recent judgment that I found very interesting is Serious Fraud Investigation Office versus Rahul Modi. It's a 2019 judgment where an issue which is perhaps often ignored in habeas corpus was touched upon by the Supreme Court. The Supreme Court reiterated that for issuance of a habeas corpus, the detention of a person must be illegal. So if somebody is arrested by the police and taken to a magistrate, for instance, right, you have to be taken to a magistrate within 24 hours after arrest, and the magistrate or the court of the magistrate remands you to police custody for 4 days or 14 days or whichever number of days, then that, in such a situation, you cannot file a habeas corpus petition, right? Because your detention in jail is pursuant to order of a court. So it is not illegal. It's a legal detention. You can challenge that order of a court before a sessions court. That's your right. But you can't file a habeas corpus petition because your detention is not illegal. So only where your detention is completely illegal, somebody comes to your house, says that I am acting on behalf of a particular authority, SFIO or state police, and I will just simply arrest you and take you in custody without disclosing to you under what law, for what reason you're being arrested, no arrest warrant, nothing at all. Those are the cases perhaps where habeas corpus can be invoked. Habeas corpus can also be invoked. There are judgments of the Supreme Court to say where you have not been arrested, but where your arrest is imminent, or somebody is threatening you with arrest. Even in such cases, you can approach the Supreme Court to say that the process under which I'm likely to be arrested is bad in law, and therefore my arrest please be set aside. The second writ is a writ of mandamus. Now, a writ of mandamus is issued by the court directing lower courts to perform certain actions, right? So, for instance, you applied for a license, a driving license, you've passed your driving test, but the driving authority does not issue you a driving license. So you can approach the High Court. The High Court will tell the driving authority, the transport office, that I'm issuing you a mandamus. Please issue him or her the driving license if he or she is otherwise qualified to be issued. So mandamus is a direction, is an order by the court directing a lower authority to do something. The third is a writ of prohibition. A writ of prohibition is that, for instance, proceedings against you start in a particular tribunal and you find that the proceedings are absolutely absurd or bad, or the proceedings are being carried out under a law which you think is unconstitutional. Then you can approach the High Court to say that, sir, I am party to a proceedings which are being carried out under a law which I think is unconstitutional. So therefore, please prohibit the court below from continuing these proceedings against me. And the court, if it is satisfied, will prohibit the lower court, the inferior court, from continuing any proceedings. So writ of prohibition, as it literally says, is issued by a higher court to prohibit a lower court from continuing to do something which you think is ultra vires or unconstitutional. The fourth writ is a writ of quo warranto. The quo warranto has been sparingly used, but has been used quite often in India, where service law domain is very active and is a huge field of law. Quo warranto is a writ where a citizen or a resident of India can go to the court and say that, see, somebody who's holding a public office is actually not qualified to hold that office. For instance, there's election commission, there's electricity regulatory commission. There are several bodies under the state. Now, those bodies will prescribe certain conditions that the chairman of a particular body must hold certain degrees, that a particular teacher or a particular managing director of a corporation must have ABCD educational qualifications. When you come across an incident where somebody does not hold those qualifications but has still been appointed, then you can approach the High Court and say that, see, he's holding a public office, which means it's not a private office, which means he's not working in a private company. He or she must work with a government company or with a public body, and that person's appointment is bad in law. Then the court can issue a quo warranto to say that, yes, that appointment is bad and I'm removing him or her from that post because he or she does not meet the educational qualifications. And the last, fifth prerogative writ, perhaps very often used, is the writ of certiorari. A writ of certiorari is in the nature of a corrective writ. A corrective writ, as it literally means, is when a lower court or a public authority or a government authority has passed a particular order, already passed a particular order, and there are some patent absurdities with that order which violate any of your fundamental or legal rights. Then you can approach the court to say that, see, state has acquired my land without giving me an opportunity of being heard, or state has passed certain order removing me from a particular post in a state company without giving me an opportunity of being heard, or without complying with the rules that state was supposed to follow. So therefore, please quash the order of the state. That's when a writ of certiorari is issued. The High Court or the Supreme Court will issue a certiorari and say that I am issuing a writ of certiorari to quash the order issued by the state altogether, because the order is bad in law, violative of natural justice, ultra vires, unconstitutional. All those can be the grounds. Right. Then the last two bits, which I'm going to touch upon, I know we are almost out of time here, is I wanted to discuss PIL and one particular aspect of PILs. Now, PILs is an offshoot of writ jurisdiction in India. Please keep in mind that Articles 32 and 226, they're couched in very broad languages. They started out by saying, and fortunately for us, the courts in India have expanded their meaning even further to incorporate a whole gamut of rights which were not specifically carved out in Part 3. Right? So, for instance, right to live in clean and free environment, right to roads, right to healthcare, right to education. All of these are not specifically mentioned in Part 3, but have nonetheless been read as part of your fundamental rights. Now, a lot of it is thanks to public interest litigation, which originally in late 70s and early 80s, as most of us know, was incorporated as a concept to come to the aid of those who are less fortunate and those who could not approach the courts to seek redressal of violation of their fundamental rights. Therefore, anyone could come approach at their behalf, provided they're coming with clean hands and full disclosure. Now that cycle has sort of waved out, and it peaked out in the early 90s, late 90s and early 2000s. And since then, there have been numerous instances of abuse of public interest litigations as well, which is what I wanted to touch upon. A lot of us know of the good work that public interest litigation has done. It's extensively dealt with in our curriculum, Justice Bhagwati's judgments, MC Mehta cases, DK Basu, Sheila Barse. A lot of those cases are something that most of us are familiar with. rights of prisoners, rights of under trials, environment issues, all of them have been dealt with by Supreme Court and various high courts in exercise of public interest litigation, and writs have been issued directing the state to do certain acts. There is one case particularly, however, that stands out. Read this, please, if you have time. Justice Bhandari's judgment, State of Uttarakhand versus Balwant Singh Chaufal. It's a 2010 judgment where the Supreme Court discusses the issue of public interest litigation at length. It discusses how PIL evolved, how courts, in which kind of situations have court, Supreme Court or High Court interfered in exercise of public interest litigation jurisdiction, and how PIL have also been abused by certain people. So some people, for instance, will use PIL to settle scores, personal scores. Some people will file PILs at the behest of a vested interest, right? A particular company is carrying out illegal mining in a forest, and the other company which failed to win the tender will put up a proxy litigant and file a writ petition through that proxy litigant in the High Court. Now, when the High Court says who this proxy litigant is, what are the qualifications, what work have you done, they have nothing to show. And it's found out that this proxy litigant is actually being funded or acting at the behest of a competitor. Now, those are instances where the concept or where the invocation of a PIL is being abused by a lot of people. So that's what Supreme Court reprimanded in this particular matter, and said that you must approach the courts with clean hands. You must approach the court for right issues. Please do not approach the court for your personal or vested interests, right? So that's why I think this case assumes certain significance. And a lot of high courts across the country then formulated their own rules to limit, in a way, the exercise of PIL powers. Not everyone can file a PIL. You must disclose a whole host of things before your PIL is now admitted. So court's approach to PIL today is very different from what it was 15, 20 years ago. They are often checking the credentials of the public interest litigant first and satisfying themselves about it, and then proceeding to hear the case on merits. Right. Lastly, these two articles, 32 and 226, we've had a whole discussion on this for almost the last hour or so, assume a lot of significance, not only for the reason that we just discussed, but also because a number of judgments have held that these two articles essentially are the repository of court's power of judicial review. And judicial review has been held to be a basic feature of our constitution. So it is something that defines, if you were to pluck out that what are the 10 most important ingredients of the Indian constitution, these two articles would find mention. Because it is these two articles which give the power to the Supreme Court and the High Court to issue any writ or any order or any direction to protect the rights of Indian citizens and even non-citizens in several cases. The source of the court's power are these two provisions. And therefore, court's power to review the action of a state or even a private individual, the court's power to review those actions are sourced to these two articles. And in for instance, L. Chandrakumar, in Minerva Mills, in a number of other cases, I.R. Kolo, the court has held that this power of judicial review is unamendable. One cannot tamper with Article 32 or 226 in a way to oust the court's jurisdiction. Parliament cannot tomorrow make a law and say that I will make a law and I will acquire people's land, and nobody can file a writ petition under Article 226 or 32 when their land is acquired under this act. Any statute which has a provision like this is liable to be struck down as unconstitutional by the Supreme Court and the High Court on the ground that it not only takes away a fundamental right under Article 32, but also impinges upon the basic feature of judicial review. So court's review of state action is guaranteed by these two provisions, and that review cannot be diluted. So therefore, it's a huge protection for us living in this country. We're looking at what's happening in a lot of other countries where people's right to approach the courts, where people's right to demand certain action against the executive and legislature are severely restricted. There are no such restrictions here, thanks to these two articles. And thanks to a whole body of judgments which have held that you cannot even dilute these articles. So please, the parliament or state legislature, do not even consider or think about restricting people's access to these two articles. I don't know if you've read ADM Jabalpur's judgment, but perhaps one of those judgments passed by ratio 4:1, where Supreme Court held that yes, access to Article 32 during the period of emergency is restricted was heavily criticized and subsequently overruled as well. But that was perhaps an isolated incident in our judicial history. But thereafter, the position has been clear as far as courts and jurists and scholars are concerned that these rights are basic features, cannot be taken away. One can approach the court, but you must ensure that you take certain precautions, disclose all the details in good faith, tell the court what right is violated, tell the court you've done your homework, that you've approached the authority, that I have this right, please give me this right. If you don't, then I will approach the court. All of those details must be given to the court. And then courts are likely to come to your aid and rescue. I mean, we're saying this from day-to-day experience where a number of writ petitions are filed every day in various state high courts and in Supreme Court. And Supreme Court acts on a lot of those petitions, finds merit. With that, I think we've touched upon a lot of these issues, and I thank you all for being such patient listeners and for being such a good audience. Thank you, Rahul. Thank you, Sanpreet ji. Thank you, Professor Bahugana, for giving me this opportunity. It's always a pleasure. Thank you.
Thank you for lightening us with your views, sir. Now I humbly request Sanpreet sir to address the attendees.
Am I audible?
Yes, sir.
Respected Bahugana sir, respected Poonam Rawat ma'am, dear Ajit Sharma, Rahul and Abhijit. Though Mr. Sharma has broadly covered the issue regarding writ jurisdiction, but I just want to educate myself as well as I just want to speak on the topic with regard to my experience with regard to writ jurisdiction. To understand the writ jurisdiction, Article 226 and Article 32, one must first understand Article 12 of the Constitution of India. As Mr. Sharma has rightly said, that it can only be invoked against the government. Article 12 has been designed in a manner that it also includes the government, Parliament of India, and the legislature. And in a last conference, Justice Singhvi has rightly educated us that it also covers to the extent judiciary also. So if you want to maintain a writ petition under Article 12, under Article 226 of the Constitution of India before the High Court, or writ petition under Article 32 before the Honorable Supreme Court of India, you must understand that the writ can only be sought against the government or its instrumentality, which is defined under Article 12 of the Constitution of India. And yes, rightly said by Mr. Sharma that there is hierarchy of courts. We have municipal courts, which we also say magistrate courts, sessions court, then we come to High Court and Supreme Court. Yes, the remedies are there, and we have to, as by way of rule of convenience, we have to approach from the lowest forum, not directly to the High Court or Supreme Court. And yes, there are alternative remedies available to us, even for redressal of these remedies, even for redressal of breach of fundamental rights. We can approach to the courts below. But yes, the Constitution framers kept in mind, they were very vigilant by giving this remedy, by providing this remedy, that it can be remedy anywhere where there has been injustice, and an effective remedy. If supposingly, for instance, there has been a breach of fundamental rights and we approach to the lower forum, the procedure is very lengthy. We have to file, there is law of pleadings, law of evidence. But here when we approach to the writ courts, High Court or Supreme Court, the procedure is quite convenient as compared to the lower judiciary. By exchange of affidavits, the courts come to the conclusion and decide and adjudicate the matter in the right perspective. It's cost effective as well, it's time effective as well, and redressal, effective redressal of your grievance. Now comes that when we invoke these jurisdictions under Article 226 of the Constitution of India or Article 32 of the Constitution, one must bear in mind that he has to approach to the court with clean hands. Supposingly you are invoking these jurisdictions and you conceal or suppress certain material facts, then you are not entitled for court relief, even if there has been breach of your fundamental rights. Then of course, alternative remedy. availability of alternative remedy, to my experience, does not bar the jurisdiction of the High Court completely. Bar, I must say, completely bar the jurisdiction of the High Court. In certain cases, even in tender disputes, contractual disputes, right from Gunwant Court to ABL International, there has been different views of different benches with regard to the maintainability of the writ petition under Article 226 of the Constitution of India. Even in ABL International versus Export Credit Guarantee, the Supreme Court went to say that even in disputed question of facts, if the court can entertain a writ petition under 226 and to remedy injustice, they can even call upon the evidence by way of affidavits, or even they can even take evidence of other documentary evidence also. Now, the basics of this writ petition is to seek a command in the name of the court. Whenever we approach to the court, we say that there has been a violation of our fundamental rights and the command is necessary, then the court has ample powers in terms of prerogative 5 writs, which Mr. Sharma has already educated us. The court can command the respondents to act or to restrain itself from doing such act. Now, these are the basic things. Now, what is the basic difference between 226 remedy and Article 32 remedy to my understanding of law? Supposingly, let's take an example. Supposingly, there has been, if we wants to seek a direction pan-India, then of course we can apply under Article 32 of the Constitution of India. Here I would like to give an example of the case filed by the Youth Bar Association of India versus Union of India. Firstly, we filed a writ petition in the nature of public interest litigation before a particular High Court. Let's take an example. We filed a writ petition before the Allahabad High Court, seeking a direction for the state of Uttar Pradesh to start uploading the FIRs in the police website, so that since it is a public document, it can be obtained easily. The Allahabad High Court issued the directions, and on the basis of that directions, the state of Uttar Pradesh started uploading the FIRs. Then we thought that why it should be confined to only one particular state. So I filed that petition before Uttarakhand High Court also, but that remained pending. During the pendency of that, we filed a writ petition before the Honorable Apex Court by arraying all the states as respondents as well as Union of India, and the judgment was delivered by Justice Deepak Gupta, and it has been reported in 2016 SCC, Youth Bar Association of India versus Union of India. By that judgment, the Supreme Court directed all the states as well as Union of India to start uploading the FIRs in the police domain. This is one aspect. Now coming to the issues arising out of tender disputes or other contractual disputes, whether this public law remedy is available to us or not. There has been I must say, there has been different views of different benches, but ultimately the law has been settled in 2014. I just quickly give you the citation of that judgment. That is AIR 2014, Supreme Court 390. The citation is Ma Binda Express Carrier versus Northeast Frontier Railways. In this, the Supreme Court said only there are two contingencies where a jurisdiction can be invoked in tender disputes. Firstly, the Supreme Court led that if the decision of the authority is arbitrary, then the writ court may interfere in the matter. And second, if the public interest is affected, then of course the writ petition can be entertained in exercise of writ jurisdiction under 226 of the Constitution of India. To my understanding of law, this is all self-imposed restrictions. The law framers, while drafting the Constitution, have carefully analyzed the scope of Article 226 of Constitution of India and Article 32 of the Constitution of India to effectively remedy the injustice. Then comes when The writ jurisdiction can also be invoked in a public interest litigation. We invoke the same very jurisdiction in Article 226 and Article 32. Then there is also one more aspect. You may also read down the judgment of Rupa Ashok Hurra versus Ashok Hurra, wherein even after the dismissal of your appeal by the Supreme Court and subsequent dismissal of your review petition and the mercy petition as well, if you can establish that there has been a violation of natural justice, and that has to be rare, not regular, you can maintain a writ curative petition before the Honorable Supreme Court even after the conviction has attained finality. So these are the aspects, and in those also, and like Mr. Sharma has also said that in election petition, we cannot directly approach the High Court and Supreme Court that, look, there is a violation of fundamental rights. There are remedies available to us, and as per the hierarchy, we have to follow that. And the law is settled in Mohinder Singh Gill versus the election, the chief election matter. The Supreme Court has in specific terms said that in election matters you cannot invoke jurisdiction, since there has been disputed question of facts. The term disputed question of facts is very relevant whenever we talk about the writ jurisdiction. In number of Katanov judgments, the Honorable Supreme Court has stressed upon whenever there is disputed question of fact, the writ jurisdiction, the writ court cannot adjudicate it upon, because it's a lengthy process. It requires appreciation of evidence. It requires appreciation of the cross-examination and the procedure to be followed to find out the veracity of the allegations and the counter allegations. So, to my understanding, is to law is Article 226 and 32 are basically meant to help the persons who are really aggrieved by the action of the state. And the state has been defined under Article 12 of the Constitution of India. And in pension matters also, if we take an example of the pension matters, there has been the government for time and again, they have been, I must say, exploiting the employees by all these means, and the writ jurisdiction is only the possible remedy where we can seek the indulgence of the court and seek a direction for the government for issuance of mandamus so that their pension may be released. And thank you so much for hearing me, allowing me to share my views. Thank you so much. Over to you, Rahul.
Thank you, sir. Sir, we have been receiving questions on our group chat, and also we have been receiving questions on our mail. Some of them have been shortlisted, which we will be asking from sir. So I request the speaker to kindly answer them.
Hello, sir.
Sure.
So there's just, am I audible?
Yes, you
So
are.
there's this question, like you emphasized on the guarantee provided in the Constitution in these articles, Article 32 specifically, and you also said that whenever the Supreme Court feels that the matter is not pressing enough, they ask to exhaust the alternative remedies first. So whether this order of dismissal by the Supreme Court on this particular ground is subject to a review petition?
Well, there are two things. One is, in such a situation, normally the Supreme Court will ask you to withdraw your writ petition and approach the appropriate forum. In which case, it is your option to withdraw your writ petition because you've approached an incorrect forum, and to seek liberty from that court that I will withdraw this writ petition, and the withdrawal of this writ petition in law will not have the effect of res judicata, right? For instance, if you approached a wrong forum under the mistaken assumption that that wrong forum is the correct forum, then technically it is not a dismissal by the wrong forum unless you insist on getting a dismissal. Once the court tells you its mind that, see, you approached us wrongly, we are not inclined to interfere in this matter, we feel that a court closer to your home in Lucknow or in Nainital is better suited to decide this matter, please go there. Then it is only fair for you to say, all right, then I will withdraw this petition and approach the appropriate court which you say. Please mention in that order that I am withdrawing it. And then you can approach the concerned High Court, and that High Court will not tell you that the Supreme Court refused to hear your petition, so I will also refuse it. There's no res judicata effect. But if you insist in the second situation, as your question is, If you approach the Supreme Court says approach another forum, but you say that no, I will not approach another forum and I want you only to hear it. And Supreme Court will dismiss the matter, saying that we are an incorrect or inconvenient forum. And any dismissal by Supreme Court in a writ is subject to review jurisdiction. That's under Supreme Court rules. Right, under Article 145 of the Constitution, it empowers the Supreme Court to make rules. Similar to the, I think similar to the test prescribed in Order 37 CPC are the criteria under Supreme Court rules for invocation of a review petition. Extremely rare, however, that something like this will simply be reviewed.
Thank you, sir.
Yeah.
Sir, another question asked by one of the participants is, sir, in case of violation of the fundamental rights, sir, how to decide which forum to reach, whether High Court or Supreme Court?
So, as I said, your first priority should be, even before you approach High Court or the Supreme Court under writ jurisdiction, please see whether there is an alternate remedy available, which is efficacious. If there is an alternate remedy available, then writs are not the option. The alternate remedy is. If the alternate remedy is either not available or is available but is not efficacious, is not effective, is not convenient enough, then you approach as a matter of principle first the High Court under 226. Is not only closer to you, but it's also has wider powers. High Court's power under 226 is to enforce not only fundamental rights, but to issue writs for any other purpose. So it has a much wider power. So your chances of success are probably higher in the High Court. Thirdly, also as a matter of convenience, the Supreme Court has been insisting litigants to first approach the High Court and then approach the Supreme Court. That's purely as a matter of judicial propriety. There is no hard and fast rule. So my suggestion is you follow that judicial propriety, approach the High Court unless there are compelling circumstances. For instance, right now, during the time of COVID-19, for instance, a lot of people who are based in say Noida or based in Ghaziabad, it's inconvenient for them to approach their parent High Court in Allahabad because that's just not functioning. There's not functioning at all. Not even online hearings are going on. They're closer to Delhi. Delhi Supreme Court is hearing online petitions, urgent matters. So in such a compelling and rare situation, someone like them can perhaps file a 32 in Supreme Court and tell the Supreme Court, why am I filing a 32 and not a 226 is because of this reason the 226 High Court is not functioning.
I may add to that.
Yes, sir.
I may share my experience with regard to Article 32 petition. With regard to payment of pension of a lady, 97 years old aged lady, her husband was employed in West Bengal police, and by the time he passed away, she applied for pension and she was denied pension for almost 15 good years. She was residing in the state of Uttarakhand. So she came here that I need to file a writ petition before the state of Uttarakhand for invoking my right with regard to pension, with regard to payment of pension. But the writ petition in Uttarakhand, by airing the state of West Bengal as a party, would have not been maintainable. And she was virtually asked to go to the West Bengal High Court, Calcutta High Court. So I filed a writ petition before the Honorable Apex Court, airing state of Uttarakhand as well as state of West Bengal as a party. And there the Supreme Court entertained the matter, called for counter from both the states, and ultimately the writ petition was decided and she was given the benefit of pension. By saying so, I just want to inform you that since two states were involved, therefore the writ jurisdiction under Article 32 was invoked. Another example, there was a crisis due to Chamki fever, which occurred in the state of Bihar as well as the state of Uttar Pradesh. In that eventuality also, my worthy associate and your alumni, Mr. Manohar Pratap, he invoked the jurisdiction of the Supreme Court under Article 32 and the writ petition was entertained because two states were involved in that. So in that eventuality, the Supreme Court will not ask you to go to one particular High Court. Though in Article 226, 1 or 2, you will find that even the High Court, and supposingly if you are invoking the jurisdiction of Uttarakhand High Court, even that can pass a direction with regard to state of Uttar Pradesh also. But that is on rare circumstances. So this is the slight difference that one must choose why we should first go to the High Court or directly to the Supreme Court.
Okay, thank you so much, sir. Sir, now I would like to request Ms. Priya, President of Moot Court Society, to deliver vote of thanks.
Good evening, everyone. So, without taking much time, on behalf of the Moot Court Society of Law College Dehradun, I would like to propose a quick vote of thanks, thanking first of all Mr. Ajit Sharma, who gave us his valuable time in these times when getting an internship or accessing to study material is very much difficult for students like us. This lecture has been very helpful to all of us. Next, I thank Mr. Sanpreet Ajmani, President of Youth Bar Association of India and Supreme Court Advocate, and also Youth Bar Association of India for providing us technical support, without the help of which this event wouldn't have been possible. I also thank Dr. Bahuguna and Dr. Poonam Rawat for their constant support and encouragement. And lastly, I thank over 200 participants who have joined us and made this event a success.
My dear friends, I was listening, I have gone through the entire speech and I was very happy to see my students when they speak from the dais where more than 200 students all over the country are appreciating and listening. They are asking questions, very relevant questions. So it is a proud moment for a teacher. So all the blessings are with you, Mr. Ajit Sharma and Sanpreet Ajmani and all those who are organizing this event. Anna.